The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated, everyone. We are here today for the submission of 3 cases. The first case is Estate of Tornell that will be submitted today without oral argument. Our first oral argument today is Worthwhile Wind versus Worth County Board of Supervisors. Mr. Updegraff, you may begin.
Thank you, Your Honor. My name is Eric Updegraff. I represent Worth County, Iowa in this lawsuit brought by Worthwhile Wind. I have come here to raise 2 legal issues. The first issue is that if you're going to consider whether or not there are vested rights to build a project under an old zoning ordinance, you must compare the substantial expenditures against the total cost of the right that you're doing or that you're granting. The total value of that right correlates with the impingement on the local legislators' ability to pass regulations that they believe that are valid in their circumstance. The second issue I'm raising is that I do not believe that the separation of powers doctrine allows a district court to determine that a moratorium, a legislative act, has been passed in bad faith and thus invalidate it or otherwise not enforce it. I believe that's a basic separation of powers question that the correct answer under Iowa law, both Geisler and every other case that's ever discussed the issue, is that if a district court is going to evaluate a legislative act, then it is limited to the constitutional discussions of rational basis or strict scrutiny that have existed for almost 250 years of jurisprudence in the United States of America. Let's start with John Marshall all the way back in the very beginning when they were figuring out what separation of powers means. I think the district court in this circumstance lost sight of that. In fact, the district court's decision in this case on bad faith appears to assume that the law is that there is such a thing as bad faith scrutiny of legislative actions. We would have strict scrutiny, we would have rational basis scrutiny, and then bad faith scrutiny based on the subjective intent of the legislature that passed the particular legislative action.
On that, what about Geisler's citation to Humble Oil?
Humble Oil is a case that involves a quasi-judicial action, right? The details of Humble Oil are so important. In Humble Oil, a local filling station, and it's nice to hear somebody call it a filling station, nostalgia comes back there, had applied for a permit to build a filling station within the city limits. The city zoning board had denied that permit based on a statute or an ordinance that had no standards. Humble Oil then filed a lawsuit. That lawsuit was then pending. And then in order to attempt to essentially frustrate that lawsuit, the city council passed a new ordinance that included standards to review. And what the Wisconsin Supreme Court is saying there is you cannot frustrate pending litigation. Humble Oil, in my opinion, is a retroactivity question, right? Can you retroactively apply substantive standards to moot a lawsuit that exists in a zoning case? That's not this circumstance. There was no judicial action taken by the Worth County Board of Supervisors. There were no pending applications for permits. There were no denials of permits. There were no appeals of permits that a legislative action could be interfering with.
Permits. There was some discussion in your brief that the vested rights doctrine relates to specific zoning decisions or quasi-judicial, maybe executive decisions that all involve permitting, denying of permitting, withdrawal of permitting. Is that part of the argument you're making here today, or is that just kind of?
Absolutely. I think it's the key to understanding what Geisler means, right? The first part of Geisler is a moratorium is a legislative act. A court cannot challenge a legislative act under the traditional separation of powers. If you have a problem with the passage of a moratorium, your recourse is at the ballot box. Then in the second part of Geisler, they discuss the proceedings, the quasi-judicial proceedings related to the permit. and say, hey, you cannot deny a permit with no legal basis to do so, just so that you can change the law on these people, make them start over. But that's not our circumstance here. There's 3 townships within Worth County that require conditional use permits under the existing or old ordinance. No applications had been made for those permits. No consideration of those permits have been made. There were no quasi-judicial actions for the Board of Supervisors to interfere with when it was passing a moratorium.
Standpoint, in the unzoned areas of the county, were there things that the wind company could have done that they needed to apply for before that would count as a permit, or?
I believe so. I'm not recalling specifically here as you asked me if there were things that they needed to do. I think that there were unzoned portions of the county where they could have built wherever it is, and that gets into the first issue.
Just started building. Okay. Is there anything in the record that kind of talks about, like, how much of their project was within the 3 townships that did have the zoning ordinances?
There isn't really a discussion of that, because at the time of trial, Worthwhile Wind could not tell the court exactly where they intended to build the wind turbines. I mean, one of the factual contexts that's so important to understand here is they have 160 leases, right? They also have a MISO, I sometimes say MISO, but that's a soup, but a MISO agreement that says that they can build up to 160 megawatts. They build turbines that are about 4 to 4.5 megawatts. Those are the ones that are kind of available. But at the time that the moratorium was passed, Worthwhile Wind could not tell you which wind turbine models it was going to use. That is one of the big issues that came up in the negotiations that were discussed in the bad faith concept is that Worthwhile Wind, about an hour and a half before the closed session where the Board of Supervisors was going to consider their development agreement, submitted a new list of wind turbine models. Yeah.
Or though, as long as they meet the other requirements here? I mean, did the county really care the size of these turbines?
Yes, they do. The size of the turbines has to do with a number of factors related to safety, fall distances, shadow flicker, all of those particular issues. The height of turbines, in particular the turbines that they proposed, a 7.0 megawatt wind turbine, would be over 700 feet tall. For context, the 801 Grand building is 616 feet tall, approximately. Don't quote me on it, but it's just about 600 feet. So these wind turbines, when they have more megawatts, they get more megawatts by being taller.
Those things sort of captured in the setback and the decibel and the shadow flicker in sort of other things, in other specifications?
But I'm discussing it in the context of the negotiations, because the district court, after I think improperly determining that it could apply a bad faith scrutiny, then said, well, bad faith occurred because the Board of Supervisors wouldn't agree to the negotiated deal.
I mean, reading the district court decision, I almost think there's a contradiction between saying the moratorium and the ordinance are valid and then saying they're enacted in bad faith. Well, then they're not valid. I mean, it doesn't make sense. It's got to be one or the other.
Particular circumstance, it is the most confusing portion of the decision for me. The purpose of a moratorium is to pause development until you can pass an ordinance. The only time that a moratorium could be unconstitutional is if it led to the passage of a ordinance that had no rational basis. In that circumstance, you could, I think, sit down and say that they're part and parcel with each other. But once there was a determination that there was a rational basis for both the moratorium and the ordinance, I believe that was the end of the district court's ability to challenge either one of those circumstances. And in particular, I think that's the fundamental error at law here. It's not just confusing, it's outright, it's an outright failure under the constitutional principles we operate under.
The other issue that the district court relied on, which was the sort of vested rights analysis. I understand your position is they don't have a vested right to this full project, which is sort of what they're asking for. they must have a vested right to something. They've spent a lot of money. I mean, you may dispute how much, but it's a lot. What is their vested right? What do they have a right to go forward with based on what they've done?
Has been that you cannot consider this project as 160 projects, right? What Iowa law makes a pretty clear distinction of is if you've actually engaged in construction, then you have a vested right to continue that construction. In this case, they have put seal slabs, which are essentially concrete or slabs that you build a foundation on top of on 2 of the 160 locations.
Tax credit or something, they had to start a nominal amount of construction? Is that?
So they had not purchased wind turbines. They had not shipped wind turbines. They had not built anything that I understand related to these 160 leases. But what they had done is spent money and time acquiring the rights to do so, right? And it's this question and this delineation that I have considered for a long time in this case is, can you get a vested right by studying something? Can you get a vested right in a property circumstance, not by constructing something, but instead by complying with regulations to do it, thinking about it? Now, that's not something that the Iowa courts have ever said before, and there are arguments on both sides of that particular issue. There's something to be said about requiring construction to at least give notice to the legislature that action needs to be taken, because you can do a lot of studying and spend a lot of time on employees and sandwiches and everything else.
That they had to pay MISO, right, that they had to get leases. I mean, that it wasn't just planning, it wasn't just someone sitting in their own office, right? I mean, they were going out and interacting with other people, and I think you even agree that they did pay some number of millions.
I do agree. Yes, absolutely. I'm sorry if I left you with an impression that I was trying to say that they were just thinking in their office. That I'm talking about as a legal principle is how much or what type of activities can give you that particular vested right, if that's the way this court wants to go, right? Because I think you would be creating new law by saying that a certain amount of study and effort would gain you a vested right, even if you haven't constructed anything. I don't think Iowa's ever said that before. The district court acknowledges it in their decision. The judge says, I think there's an analogy to be drawn here. My problem with it is just the question that I received earlier is what type of activities would get you that vested right? Does signing a contract with MISO get you a vested right? Well, I mean, that's part and parcel of what you've got to do to start construction. But then if you draw the analogy to the permitting cases, does ordering lumber get you a vested right even if you haven't built anything? And there's a specific Iowa Supreme Court case that says that they don't, right? That you actually have to build something, that just materials itself isn't enough. And that is the difficult question that I think that the district court really didn't get to. Because on top of it, we're talking about a circumstance by granting a vested right in, I think, 160 leases, although some of them may be in require a conditional use permit. We're talking about what is the extent of that right. Now, I've argued 300 million in this case because that's a conservative estimate. My problem with it is if you look at Exhibit 56 that the plaintiffs provided on and page 12 of it, their presentation to the Worth County Board, the one that was before them when they passed the moratorium, suggested that this project could be 445 megawatts of wind turbines. And in that circumstance, the estimate that Dan Litchfield provided at trial was $1.8 million of cost per megawatt. We're talking about a $900 million project if it gets expanded through more MISO permissions or those types of things. And we're talking about whether or not $300 million or $3 million in expenditures or $2.5 million or $3.
Interested in, maybe I need to ask Mr. Dublinske, but what are the expenditures, and I agree there's a certain category that you put aside, the expenditures that they've spent on studies, internal things, land agents, kind of brings to mind Billy Bob Thornton and that sort of thing. But putting that aside, money that they've actually spent to third parties that are independent of them, so the MISO and landowners, how much have they actually spent that they would not have the ability to get back at this point? Is there anything in the record that indicates that?
I think the best guess I have is that it's less than $2 million. I think $2.5 million is the amount that they say that they were out of pocket. But I would say that a certain amount of that was expenditures at the time of the moratorium that were spent on Mark Crowell and the land came people in this case, who were essentially spending money to try and get the right to start developing. And I don't think you can get a vested right in something simply because you've spent money to negotiate with the landowner.
On that point, the right is of a property owner, and so was there any effort to kind of delineate between like when they actually gained an interest in property? Like in the Paskey case, we didn't start counting expenses until the defendant actually, or the plaintiff actually owned the property. Was there any effort to delineate those?
For all 160 leases. It's a good idea, maybe I should have, but it's not something that I argued below. Thank you.
The worst case for your side? And if not, which one do you think it is?
I don't think Paskey's a bad case for my side because it says you have to determine this on a case-by-case basis, and you have to look at a number of different factors. And the district court in this case said, well, the total value of the project or total construction costs is only one factor, so it's not controlling. Great, but that doesn't mean that it's irrelevant either. And that's how the district court treated the total value of the right. And I think that that is an error at law. So, thank you.
Thank you, Your Honors. May it please the court, counsel, Bret Dublinske on behalf of Plaintiff Appellee Worthwhile Wind. Let me start by saying Worthwhile Wind is happy to take this appeal on the terms that the county set forth. And those have changed a little bit this afternoon, but in the brief, they say this appeal has two issues, one of which is whether rights can vest without construction, and the other is whether bad faith doctrine can apply to legislative acts. Your Honors, I think the body of case law makes very clear that Worthwhile Wind prevails on both of those, and that the county's arguments rely significantly on misreading of law. To that extent, let me start with the Geisler case, which obviously a major case has gotten quite a bit of attention already this afternoon. The county argues that under Geisler, that a legislative act can't be reviewed. I think that is a vastly overbroad reading of Geisler. The quote is accurate in the brief, but 2 lines ahead of that in the decision, the court more fully explains you can't raise the legislative act because this case was brought under a writ of certiorari. And then when you look at what Geisler actually remands back, it remands for the lower court to determine whether the change in regulations was in bad faith. Change in regulations is inherently a legislative act. Geisler actually cuts against the county's position here.
I tend to agree with you, Mr. Dublinske, that Geisler does impose some limits on when a zoning ordinance or when a moratorium is valid, if it was in bad faith. But let's get into what bad faith means. Geisler seems to suggest, and you quote this a lot in your briefing, that if you adopt zoning to frustrate a particular applicant's plans for development, that's bad faith. That just strikes me that can't possibly be right. I mean, that seems fundamentally undemocratic, that if the citizens of a county decide we want to stop a particular development and they adopt a zoning ordinance, as long as it's generally applicable, it's not, why isn't that a valid legislative act by the elected representatives of the people in that area?
For starters, and obviously you have the power to change your own precedents, but that would be contrary to U.S. Cellular. It would be contrary to what was sent back as the open issue in Geisler. But it also, in cases all throughout the vested rights, and sometimes it blurs in a little bit to legislative takings and estoppel, or regulatory takings and estoppel. But it's all about balancing the rights of the broader community about the reasonable investment-backed expectations of a particular project.
Sort of the vested rights argument. That's a different argument. And I understand but that I think those issues are separated in this case. They've been separated throughout, and that makes sense. But how can it possibly be? Assume that there's no vested right to the project. Assume you're wrong about that. How can it possibly be bad faith for the elected representatives of a political subdivision of Iowa to say, we don't particularly want this development, therefore we're going to put a moratorium on this kind of project?
Court and some of the courts that are stated in other jurisdictions have said is that it's an improper purpose for the zoning authority to use that power to target a particular project after there's already significant investment in that project, after there are reasonable investment-backed expectations in that project, right? That we balance against this forfeiture that would happen for reasonable investments that have been made. And there's plenty of cases, whether on bad faith, whether on vested rights, where the court has made very clear that, and this goes to a question you asked earlier, Your Honor, that you can have a valid ordinance that applies to other parcels and they leave those in place going forward, but you can still have an application that's in bad faith. So in U.S. Cellular, although it wasn't a legislative act, what they found was that using a device to delay to get to where they could legislate out the proposed use was an improper purpose.
Be applied, again, state legislation passed by could these kinds of principles be applied to state legislation by laws passed by the General Assembly? So for example, if the General Assembly decided we're going to put a moratorium on windmill development, pipeline development, whatever the issue is, could there be a vested rights claim there and a bad faith claim there?
Aware of any case that establishes that, but obviously there have been plenty at the county level and at the city level on both of those aspects, right? That it really is sort of directed at this zoning authority. And I have honestly not seen a case where someone has tried to apply that to the state legislature.
Or maybe one of the takeaways is there is a distinction between a county board exercising its legislative function with respect to zoning issues, and then the permitting process, which is kind of quasi-judicial or administrative. And we would allow challenges and vested rights to develop in permits and those kinds of things. But I think the general rule is that there's no vested right in legislation, which is why you can't sue the General Assembly or challenge a generally applicable law just because you started construction on a project.
Two observations, however. One is that the cases largely, I mean, the majority of the cases that have been cited in the briefs, distinguish between the general legislative power and how that gets applied to a particular case. So if you have a legislative change that was meant to undermine a particular project to zone out a particular use, right, that goes beyond the authority of the zoning authority as applied. The second thing is the state legislature is a little cleaner because they're not wearing both hats, right? So if you have a zoning authority and you have case law that says, as in U.S. Cellular, you can't use a denial for a wrong reason, in that case it was a proposed ordinance, to buy yourself time to get to where you can do it right. If the only thing you have to do is, instead of denying that original application, just pass a moratorium that same night, you've eviscerated any of the protections that the bad faith standard creates, right? So the policy reasons that this court has recognized why we don't want to let someone pull the rug out at the last second. We don't.
Though, that there needs to be a permit or application involved. So we said in U.S. Cellular that U.S. Cellular had not been issued a permit that could provide a basis for the acquisition of vested rights. And so it declined to consider a vested rights argument because the vested rights theory is a right in that permitting decision, that quasi-judicial administrative decision, not the legislation itself, right?
Note that in most of the cases where there is that sort of language, it makes sense in the facts of that case because there was actually a permitting issue at play in the case. But if you look at Paskey, for example, they had a permit to move the houses. The decision says nothing about a permit to actually modify the land or construct on those houses, which makes sense because if you look at the timeline in that case, there was no ordinance. It's sort of like the unzoned portion of Worth County here. There was no ordinance until it came into effect in the middle of Paskey's work, and that gave rise to the dispute. If you look at Kasparek, they had an approved plat for that, but there had been no, as far as we can tell from the decision, no permits to construct and no construction had taken place. So I think, part of what you see, and here, obviously, that would be an anomalous result because you would have
Again, as creating rights in non-legislative decisions, actions, representations, approval of moving buildings, approval of a plat map. This seems very different because the rule is an exception. It's a rule of decision, right? Like you apply the law at the time the relevant agency is making the decision. The vested rights rule is just an exception to that. So it seems odd to apply this doctrine when there's not even a decision that you're contesting and you're just seeking an exemption from all current and future law.
in part where Paskey was, right? There was no decision because there had been no, there was no permit. On that one, I believe it was, well, they had adopted the ordinance in the middle of his project that then resulted in the later denial. Here, the moratorium kicked in. We weren't able to continue building the project. But I look at that case, I look at Kasparek as cases where there were no permit. But going back to your point about, well, 2 points. One, it would be an anomalous result to say an identical project has certain protections in a zoned county, but doesn't have those protections in an unzoned county, which there still are several of, even though the actual change that impacts the project to go from unzoned to zoned is considerably larger. The second thing I would say is
If there's no mechanism to secure some sort of right to build, then you're kind of, as with all projects, right? Like you invest in a business and maybe the lawmaking body says, we're not going to do that anymore. Maybe you want to do gambling, the legislature says no. Maybe you want to sell CBD beverages and the legislature says no. Maybe you want to build the windmills, the legislature says no. It seems kind of how democracy works, unless you go to some agency and get a piece of paper or a representation from a government official that says, yes, you can do this and start investing money.
I think in these cases, you do see that come up in some of the language that blurs in with regulatory takings, which I think would really be your only remedy in a legislative case, right? You wouldn't have these same sort of, you don't see the vested rights or the bad faith cases. It would be a matter of a takings doctrine at that point. But I look at the body of case law and I see a couple of different ways that you can get to the vesting of the right. The court has found that a significant expenditure that was lawful prior to the legislative change vests a right. If you have a permit and one was necessary, that can vest a right. But the third thing I would say, and this goes against, when the county says in their brief that this is about as construction started, I am not aware of a single case, and the county certainly didn't cite one, where if any physical work has started, if a spade of dirt has been turned, that you do not end up with a vested right in this case. And the right is not just to complete the construction, as the county argues. The right is to complete the project. And if you want to see some examples of that,
Right, correct? Isn't that what you say? And who's the landowner here? It's not really your client. Your client is the developer. That's a little different, isn't it?
again, you've got a case like Stoner McRae that involved billboards, and those billboards certainly don't own in fee the entire parcel. Those are leases, and in that case, it talks about owned or leased. On a policy basis, we don't see why there would be any difference in a lawful right or interest in the property. And again, I think one thing that's important to note here is that there are cases like Central States Theater that talk about you can't zone out or excessively regulate a lawful business activity. And then again, there's this, the court's decision in Mathis versus Iowa Utilities Board that says when we're interpreting ambiguities in a statute, it's important to look and to note that there are statutory public policy favoring this use, and we should take that into account in engaging in our interpretation. Here, where it's not statutory guidance, but it's basically case law, it's a common law doctrine, Your Honor, we would think that would be even more true, that
money do you have to spend before you've gone beyond simple political risk of the law changing? And is that expense measured against the total value of the project, as the county argues?
very clear that the county's argument there is not supported by any actual law. What the case law says is you look at the amounts spent in compliance and see if they're substantial. This notion that it has to be compared to something literally has...
They can pretty much do whatever they want compared to someone else. I mean, 1.3%, isn't that the amount of money that was spent?
Say that the doctrine that it doesn't have to be compared to the final result, may I finish, Your Honor? It helps people who aren't incredibly wealthy, and you've seen vesting in the vested rights cases here, $600, $1,400, very low amounts. But the key is, even in Paschke, which the county relies on because it mentions that comparison, the court in Paschke doesn't actually do that. They never mention the actual amount. And if you look at cases like Kasperick, where we're talking about bare lots, the decision never mentions what the final built cost would be. In Kempf, where some of the lots were developed and some weren't, there's never any conversation about what the ultimate built cost would be. In fact, there is no case from this court where there is a discussion about what the final built cost would be. And just to clean up the record a little bit,
In Kasperick and like Stoner McRae, it seems like those address the unconstitutionality of it, and you're not bringing it, you're not saying that this ordinance is unconstitutional, you're just asking for a bad faith or a vested rights exception, right?
Kasperick, they allowed the ordinance to stand. They just said you also have to grandfather in these people in the Lake McBride watershed.
To do with the fact that it completely took the whole value of their property, and it was unconstitutional from that perspective?
Interesting point, Your Honor, because as I read the case, what they said is some of these lots are sold and some aren't. And the patchwork that we have would result in an unproductive outcome. And if you take the county seriously when they say, look, they've started these seal pads, which are concrete, 91 feet across, 13 and a half feet deep. It's a major undertaking. They've only done that for 2 turbines, so they shouldn't be able to get the rest of this. But all of this planning and everything goes to the project as a whole. It's not going to be economically viable to build 2 turbines.
Brought an argument that the ordinance is unconstitutional because it completely deprives you of your right?
Said the application is unreasonable because it will kill the project. It does deprive us of the project. Just to clean up the record on, Justice Mansfield had asked, what are the actual unrecoverable out-of-pocket? And Your Honor, I don't know that these numbers are all in the millions, including what the county can.
Ones you can't get back, because you can terminate the leases, and you can go to MercyOne and ask for deposits back. And then I'm not particularly interested in, what you've spent on land agents and consultants and things like that, as opposed to what you've actually paid to secure a lease. So in that narrow category that I'm kind of driving toward.
I think the consultants, when you consider the nature of the project, are critical, right? You've got mandatory environmental studies, you have airspace and communication path. You know, those are critical steps in the project. We talk about moving toward the use, which is the language some of the cases use.
Client develops these kinds of things. I think that's their business, as I understand it. And from reading the briefs, I understand the plan is that they're going to turn around and sell this project to someone who's actually going to finish it and build it out. And I assume they build a very substantial profit margin in there in order to account for these expenditures and the risk that the project might not go forward.
I know that they do. I think, you know, the district court found, and we think the findings of fact are binding in this case. I'm happy to talk about whether this is law or equity, but but even if you just simply give them weight, found $7 million. Mr. Litchfield said that Invenergy's revenue on this, that Worthwhile Wind's revenue on this, would be about 11 to 33. So actually, there's not, on the 11 end, there wouldn't be much profit left at all. We believe that the facts support a little more than 7, about 8 million. But to your question directly, unrecoverable from MISO is 3.8 million, and commitment to the landowners, whether paid or still to be paid, but contractually committed, is 2.4 million. So it works out to about 6.2.
But am I correct in reading the record that you can terminate those leases?
It's my understanding that we can terminate them, but not without paying for the first 7 years.
And then MISO, there's no way you can get, I didn't see them. I mean, it's a huge record. The MISO contract's in the record.
Should be, the generator interconnection agreement. And because that is now signed, we would have back all the money that's recoverable. Everything else would have been expended by MISO in the studies that led up to the contract.
MISO. I'm sorry. You. I know. We've talked about MISO in other cases. I know. Thank you.
Relief granted in this case is to allow the plaintiff to complete development of its commercial wind energy system project. What does that mean?
So, as I read the case law, and I think that the district court's ruling is consistent with this.
What is completing the development of the project? Like, what specific things do you think you have the right to do?
We can complete the wind farm that was under development lawfully at the time of the change of ordinance and the moratorium.
Construction of the actual sites? And I want to know, like, are you acquiring rights and then selling this to somebody else who's going to actually do the construction and then operate it? So what does complete the development mean?
It wouldn't make any sense to do the pre-development on a wind farm that isn't going to be allowed to be built, right? The only reason you do this is to end up with an operating wind farm connected to the grid, and an awful lot of the money was for the grid connection, right? And in cases like Kasparek, where you have a plat, but the homes haven't been built, and you get your right to finish that. In Kempf, where you have some projects that are built, some that are started, some that haven't been started, and this court says that has to be grandfathered in. They can complete those projects I
am a novice at this, so I don't know the wind energy kind of development process and the players in each role that everyone has. When your client says we are done with the development and I go into this county, what will I see?
So when we are done, we will have all of the studies to site turbines. We will have land acquisition to support those turbines. We will have a legal right to build that project out. And the only thing that will be left, as a practical matter, is frankly the easy part, the short part. I think the record is it would take about 1 year to actually bring the turbines in, stand the turbines up, sort of build those pieces and wire them together.
Else would do that.
But yeah, if you look at this,
At least all the cases I've read said vested rights are non-transferable. Do you have any opinion on the remedy in this case?
Yes, again, Paschke says that he can go ahead and get them marketable for sale. In Kasperick, the actual construction isn't going to be done by the developer. They're going to sell the lots for homes, and whoever buys them or their builder is going to build them. So I do think there's precedent that allows those to be transferable. And again, these cases talk about you have to consider the nature of the project.
Construction? I mean, you're saying we have the right to not have these zoning ordinances applied to our windmills. But what you're really saying is we have the right to do all the legal spade work and then sell this other vested right to some other company who's actually going to build and own the windmills. That seems very different than I have a right to develop this property and then sell the houses or the buildings when they're done. Like, I mean, I don't think there's anyone disputing that you couldn't build them and sell them.
About that, though, because in Kasperick, I don't think that the owner who had gotten the plat approved was in fact going to be the developer. They were selling those off pre-construction, and the record talks about some lots were sold and some weren't. My understanding is that the homeowner purchaser and their builder were going to do the actual construction, not the entity that had it platted. But I also think, again, part of this is just the nature of how wind farms are built. And frankly, there's probably a pretty easy way around it as a matter of corporate law, that the buyer, instead of buying the windmill, right, the actual wind turbine assets, just buys the LLC, right? So in some ways, it may be that there's a workaround for that. But again, consistent with what Mathis said about, look, we should be looking at public policy and not making it harder for wind development. We should be resolving ambiguities in terms of making it easier, consistent with the policy. It would be odd to say this type of project, because of the nature of how they get developed, is uniquely unprotected.
Keep you so long. Getting back to the MISO payments, because those seem like they're the largest sort of third-party payments that are non-recoverable. How much of them had been made as of the date the moratorium was imposed? And at that point, would any of the amount that had been paid, that number you're going to give me, how much of that would have been recoverable?
725, cash out of pocket, before the moratorium was entered. At some point, some of that became refundable, about 500,000, by replacing it with a letter of credit. And then, as it turns out over time, the letter of credit fees to maintain those ended up being about $500,000. So that 1.725, you'll see it in the record, shift from 1.7 to 1.2, and then the addition of 500 to maintain the letter of credit. It ends up being a wash at about 1.7 million.
All right. Again, I'm not a financial person, so let me ask it this way. On the day the moratorium was imposed, if your client had gone to MISO and said, look, we're not going to go forward, how much of the 1.7 million would they have been able to get back?
My understanding was that at that point, none of that was still recoverable, that had been spent in the planning process up to that point, and that all of that was non-recoverable at that point. All right, thank you.
Oh, thank God. Thank you, Your Honor. I'm sorry, I said 15 minutes here. I don't think you guys want to hear from me from another 15 minutes.
Oh, me. That was funny.
Yes, I think the starting point of what I'd like to comment on is the question that Justice McDonald asked, which is what is the scope of the remedy here, right? One of the, I would say, frustrating parts of this case is that the arguments that you hear from Invenergy and Worthwhile Wind is that they're entitled to continue their project. But at the time of trial, they couldn't tell you what was the full scope of their project. They couldn't tell you what they were going to build. And they can't even tell you who's going to build it. And they want to say that they've acquired a vested right under those circumstances. And I don't think that that is supported on a case-by-case basis. It is also the very basis of my disagreement with the district court about whether or not you can consider just the infrastructure of $11 million to $33 million as opposed to the $300 million right you're really conferring. Because the way I read the remedy, it says that essentially they can complete the project. So to answer your question directly, if this was allowed to go forward, you would drive into Worth County. There would be some infrastructure that you wouldn't see. It's underground, it's there, but you would most likely see 4.5 megawatt turbines that are over 600 feet tall. And you would see, in order to get to the 160 megawatts, you'd see 38 of them dotted throughout the county. That's what you would see. And in fact, you'd most likely see them in 2 or 3 townships bunched together because there's still a conditional use permit necessary to get those in the internal portions of the county. But under this rule, what the court has granted is a right in 2 townships for them to build approximately 38 wind turbines. But that is only defined by the MISO approval of the 160 megawatts, right? The reason that the quasi-judicial permitting portion of this case is so important is because it defines the vested right. In that circumstance where you've applied for a permit and said, we're gonna build 38 wind turbines and here's where they're gonna go, you've gotten far enough along in the process so that you can say you have a vested right. You're not asking for a vested right for carte blanche to be exempt from an ordinance or from legislation. And it goes to some of the other questions that were asked by the council, by the justices, is could this apply to the state legislature? And I think, yes. I think what the district court is absolutely trying to do is create here bad faith scrutiny. And I think it would apply in any circumstance where you were looking at legislation and say, well, there's a person who was harmed by that legislation. They had started a CBD, I'm not a marijuana guy, so whatever it is, they started a marijuana business and suddenly the law changed. I mean, this happened with the touch play screens 25 years ago, where the legislature said, hey, you can build touch play screens, you can put them in everywhere. If you go to Wisconsin, they're all over the place in the bars there, and they're obnoxious. And people said, we don't want them. And the Iowa State Legislature turned around and said, they're illegal now. And there was a lawsuit about that, and they said, you don't have a right, you don't have a vested right in the continuation of legislation, because it is undemocratic to say, well, we get to be exempted just because because there's an impact on us. That's a big part of what all of these cases say. When you're reviewing legislation, you don't look at the impact on any particular project because nobody has that vested right in a continuation of the legislation. So the last thing I wanted to leave you with, and I hope I'm not overstepping my bounds here, but I don't think it's a concern here, but I do want to mention that it is so very important for this ruling to address the bad faith scrutiny issue. I represent at least 10 counties, and every time they pass a moratorium, they get a letter from a wind turbine company that says, you knew about our project, you passed a moratorium, and therefore it's in bad faith. See Worthwhile Wind versus Worth County. There's a possibility, because there are 2 issues here, that you could rule on the first issue and not reach the second. But that second issue, I want to plead with you, and I know it's maybe overstepping my bounds. It is so very important for you to provide clarity on that particular issue, not just for this case, but for all the other counties.
That, for you to prevail, don't we have to reach both?
I think
No vested right, and there's not bad faith. Okay.
right.
Back a little of that Geisler language.
I think so. I think the language is, I think it's sloppy there. I think it misses those things. I mean, one of the things that I've said, at the risk of being impertinent, is that if you were taking the bar exam, or if you were in law school and you wrote that a legislative act was invalid because it was passed in bad faith, I don't think you'd get a passing grade on that issue. I just don't. I don't think that's correct. I think it is undemocratic. I don't think you would, I'm not sure that you would pass your high school government class about separation of powers on those issues. And I know Mr. Dublinske said, well, Geisler's writ of certiorari case. The separation of powers doctrine doesn't end in writ of certiorari cases. Declaratory judgment actions don't allow you to circumvent those particular issues. So I see my time's done. If nobody else has any questions, I'll let you go. Thanks.
Worthwhile Wind versus Worth County Board of Supervisors is hereby submitted. We'll have a brief pause while we have the attorneys prepare for the Department of Transportation versus Honey Creek Drainage and others.
Great work, Brent. Thank you. They removed the push-pull signs.
Looks like the parties are ready. We're here today for the oral argument of Department of Transportation versus Honey Creek Drainage and others. Mr. Goodwin, you may begin.
May it please the court, counsel. IDOT proposes to increase the elevation of the drainage district's levees that run parallel to Interstate 29 and Interstate 680 in Pottawatomie County.
You direct me to that in the record. You say they requested, like, where is it in the record? Was it in the form of a letter? Was it a phone call? Was it testimony? Where is that? Or if you can just tell me.
The engineer, John Rosengren, who was the member of the classification commission, advised me that DOT came to the Board of Supervisors with a proposal to increase the elevation of the levees that are parallel to the interstate highways. So my understanding is that the DOT came to them, to the trustees, and then he as the engineer for the drainage district.
I mean, that DOT came to him. Where is that in the record?
His affidavits, he states, excuse me, that it all began when the DOT came to the drainage district trustees to elevate the road. And so that is in his affidavit that was part of the motion for summary judgment. Again, IDOT wants to raise the elevation of the levees parallel to the interstate highways to reduce the flooding on the interstate highways by 83%. The estimated cost of the project is...
About the record, I thought IDOT says that they are not proposing that they haven't proposed it, and that there are other mitigation measures that are more cost-effective, and that they don't want to raise the levy.
They have said that. Excuse me, they have said that. I know we are here because basically the project estimated cost is $12.9 million.
Which one is in the record?
My understanding, and John Rosengren was had filed the affidavit, he explains that the DOT came to him and proposes this project. And so the trustees wanted the Compensation Commission to determine what is going to be the cost, because they don't want to just jump in, start constructing, have it constructed, $12.9 million later, and the DOT says, we'll pay $360,000. So they, out of precaution, at the request of the DOT to consider increasing the elevation of the levees, to actually decrease the flooding of the interstate highways by 83%, did a classification study to determine what the estimated costs are and who's going to pay what. The project itself will reduce the flooding from 18 days to 7 days, but that doesn't benefit landowners because crops flood out within 4 days. The compensation, the classification commission determined that 75.7% of the DOT's proposed project benefits the interstate highway properties. The DOT, as I say, wants to pay $360,000, which is 2.87% of the cost. And that's the rub that we have here. The
percentage of the land is owned by DOT? Is DOT land? What percentage of the land is DOT land?
They want to do it on the basis of land, and they own about 4% of the land. And that is the that's the issue, because under 468.44, and that's been recognized since the 1908 case of Chicago Northwestern Railroad. The Code of Iowa establishes 3 different classes or divisions of land within a drainage district. It's railroad property, highway property, and agricultural land. And section 468.44 subparagraph 4 says any specific benefit other than draining agricultural lands shall be stated separately. And that's what the Classification Commission did when they stated that 75.7% of the benefit of the proposed project goes to the benefit of IDOT's interstate properties. So there is a difference and a distinction between railroad property, highway property, and agricultural ground.
Let me ask you this. Isn't the concern that they were really thinking about the users of the highway versus DOT itself? Isn't that the argument?
The users? Well, to determine what is the benefit, the Classification Commission looked at the Federal Highway Administration's determination of liquidated damages from highway users' use of the interstate highways. And that's where they made a determination, again, of 75.7% benefit from the project.
Case that would support that use of the federal standard?
Simply that there is a requirement that any specific benefit other than the drainage of agricultural land shall be stated separately. And so the classification commission did determine on the basis of, because you have this public property and the interstate highway, and how do you determine the benefit under section 468-44, how do you determine that benefit? Because again, the benefit is to be, if it's not agricultural land, it has to be separately stated, and that's what they're doing.
I'm thinking about we had a railroad case in 2022, Union Pacific, where there was kind of a similar question with regard to railroads, right? And our bottom line on all this was that the commission should ask, how much money and effort would a railroad company be saving if it had this improvement, a tile or a ditch to divert water out of its way? I wonder why we wouldn't apply the same standard for the DOT.
Talking with Mr. Rosengren, they very careful about that case. They don't want to talk about cost. It's a matter of benefit. They have to look at benefit, and they strongly looked at what is the benefit.
Didn't we in fact talk about benefits in these terms? In the case, in the assessment of benefits, we look to benefits or advantages of having a drainage improvement on the property. We consider the past flood damage and so forth. In other words, and then the quote I just gave you, weren't we talking about benefits in that situation too? Okay.
They very diligently made an effort to look at benefit, because I think you're talking about the Union Pacific Railroad case, 2012.
2 is the one I'm looking at. Yeah, Union Pacific. Yeah. We're on the same.
Right, yeah. And so they wanted to very carefully look at benefit because their understanding of that case is that you're not supposed to look at costs. And so they looked at the benefit. And the big issue we have here is that the district court ruled that, a drainage district is a political subdivision of the county. And that is erroneous because the Worth County case, the Mitchell case, and the Des Moines Waterworks case hold that a drainage district is a sui generis. And that means that they're unique, one of a kind, and not in they're in their own classification. And they.
Another issue. DOT at some point in their briefing makes a point that if we were to agree with you and vacate what the court below did, then that reclassification remains in effect, and as a practical matter would continue to remain in effect for other improvements within the drainage district in the future, regardless of whether DOT actually derives 75% of the benefit of those other improvements. Is that correct?
Correct, yeah. Under section 468.49, it provides that indeed the classification that is set is going to be the classification used for all future assessments unless reclassified. Okay, but what we have here is they're raising the elevation of the levees, existing levees parallel to the interstate, a foot, $12.9 million. And so those improvements will remain, and the benefit will always be the same. The classification report determined essentially the benefit to agricultural land is 9.8%. And that is always true because that elevation, the levee will always be there to provide that same, same amount of drainage protection.
Back to my threshold issue, before we even get to what you're talking about. And by the way, I know exactly what you're talking about. That's my neck of the woods. I know what highway it is, and I know why they did this, or why they want to do this. I can't get my head wrapped around, did you really have to do it or commit to it? I mean, I'm looking at page 9 of a 10-page letter dated March 10th of 23 from Assistant Attorney General Rousseau. It was addressed to the Potawatomi County Auditor. The state of Iowa has elected to armor the shoulder of its highways against erosion, reroute traffic along alternate routes until floodwaters subside, and then clean up any debris left behind on the highways. That approach is a more responsible use of taxpayer funds. Makes it seem to me like this ain't their idea. Help me, where can we point to where you guys were actually told, do this? Because I know DOT is a big hammer. If they tell you to do something, I'm sure most people will do their best to comply. Where's the do it?
The DOT has requested an improvement. Under Section 468, 126, there are repairs and improvements. Repairs are mandatory, improvements are discretionary. So the DOT is asking for an improvement to elevate, make the levees larger. So there's no demand, absolutely have to.
This letter makes it seem like they're not suggesting levies, they're suggesting, and I don't like their plan either, by the way. I don't want to take a detour and all that stuff. But that's what they said. They said, we prefer this. We think it's a better use of taxpayer funds. Where did they actually say raise the levy?
Where do they say that?
Demand for you to do that.
Again, as Mr. Rosengren advised me, and the trustees, DOT came to them and said, we have this proposed project.
In the record, I've been doing a search of buzzwords trying to find that. Where is that?
My recollection, Mr. Rosengren, in his motion for summary, in an affidavit and motion for summary judgment, explained how they came to the trustees and then involved him as their engineer to have this project to raise the elevation of the levees.
To follow up on the chief's question, the assessment or the reclassification by the drainage district, isn't that only happening because now the drainage district has decided that they want to go ahead and do the improvement themselves?
No. They don't want to get in the position of going and building something and then being told by the DOT, we're not going to pay for it. They, oftentimes a drainage district will do the work and then have a reclassification. They saw in this situation, no, we're going to have a reclassification before we ever spend a dime on construction to see how much it's going to cost and who's going to pay what share. So this is an improvement project. It's totally discretionary. The trustees at this point can say, we're not going to do it.
So if we affirm the Corp below, the trustees could say we're not going to do it.
But they're trying to cooperate with the DOT, who says, we want this project, which will decrease the flooding on the interstate highways by 83%. And so the trustees, I think in a very smart, careful mode, had the classification commission reclassify the property, find out it's going to cost $12.9 million, and who's going to pay what? Because the landowners aren't, well, they've determined that the benefit is less than 10%, and for the landowners, there's still the possibility of flood insurance. So we have a discretionary situation here with the trustees. They don't have to build this improvement.
We were to apply, say that the commission ought to apply this standard from the railroad case that we were discussing before, about how much money and effort would the DOT save if it had this improvement. What percentage would the DOT need to pay then? Do we know?
Classification report. Okay. About, let's say 75% of the benefit of the project is for the DOT. The remaining 25%, okay, there's a little bit less than 10% for the agricultural land, a little bit less than 10% for secondary roads, and then the remaining 5% for the railroads that are there.
Try to focus in, because I don't think I asked my question very well. Do we know how much money and effort the DOT would be saved? The DOT would be saved. How much would they be saved by this project? How much money? Mm-hmm. Do we know? Or is that?
I don't know that the reclassification commission figured it that way.
That issue. They didn't reach that issue.
Right. Generally, well, they have to do a reclassification. They're doing a reclassification report, and that can be appealed. And the issue we have here is the district court said we're going to treat drainage districts as a political subdivision, and they're not a political subdivision. And so the process is actually, with the case of Fulton versus Sherman, the proper way to challenge a reclassification report is for the party challenging the reclassification report to also make their own reclassification report. That way they can see, because there's a strong presumption that the reclassification report is correct. And so what we're really saying is go back to district court. The DOT can do their own reclassification report and submit it and have the district court compare the reclassification report by the engineers and by the DOT and see what's correct.
We'll let you come back on round 2 here. Mr. Rousseau.
Good afternoon. May it please the court, counsel. With your permission, I'd like to make 2 brief points to explain what the state of Iowa is seeking. In this case, first and foremost, we ask that you affirm the district court's holding that 307.45 applies to drainage districts as political subdivisions of counties, and that the DOT property, therefore, must be assessed in the same manner as private property. And the second thing we urge you to do is to clarify the scope of benefits under Chapter 468. Can that term benefits be extended to users of property, in this case passing motorists, to justify assigning 75% of costs?
On that seems way off base to me, because the whole idea of when the government does something, the government isn't in the business of doing something in order to make money. If they go and open a school, the benefits are not, what you can earn by renting out the school at night to somebody else. The benefits are the kids you're educating. And similarly, when you have a highway, the benefits of the highway are the people that use the highway. And the government doesn't charge those users and doesn't bring in money literally for people to use the highway. But in that case, if it's land on which there's a highway and you look at 468.40, the benefits such land shall receive have to be the benefits from the users. That's the whole nature of government, isn't it?
That's a scary thought if it's public use property, because we're opening, it's opening us up to these grossly.
Property.
Property, correct, yes. Publicly owned property that is used by the public, yes. But it opens the state up to these gross disparities in assessments that we see here, where a property owner, a public property owner owning less than 5% is going to shoulder 75% of the burden of new improvement.
Property. You can't even get across the, quote, street because of your ownership. You guys have a significant piece of property in that chunk of land. Nobody else can do anything with it. I mean, you guys rule the roost on the land that you own. That is not just a chunk of land that has some corn stalks growing. It's significantly different. Wouldn't you agree?
I would agree that the use is different, and that's the reason why the legislature saw fit to enact 30745, to avoid this type of gross disparity in assessments. If it has to be assessed in the same manner, then we're talking about objective measures, such as land area, land elevation. And I would submit that land at a higher elevation, such as the highways, among the highest elevation land in Pottawatomie County, benefits the least from flood improvement measures because it's going to be high and dry. The lower level properties would benefit more. And so even on that basis, I find it hard to believe that the highway property is benefiting 75%. But this just points to the need for interpreting 30745 in the way that we're asking the court to.
To that, 307.45 refers to cities and counties. It does not say, as other statutes do, and political subdivisions.
And I understand there's been a recent trend in legislations to spell out those various subdivisions. However, back in 1986, I'm not a legislative historian, so I don't know if they were doing that practice then, but it certainly makes sense in this case where the drainage district managed by the trustee found its genesis at the county. It was created by the county. It was originally under the supervision of the Board of Supervisors for the county. And then later on, at some point, it was assigned to a Board of Trustees. And its current operation is integrated with the county. Assessments are collected by county officials. They're dispersed by county officials. The Board of Trustees have to prepare and submit annually certified financial audits to the county auditor. And so this Board of Trustees, which has the power of eminent domain, has the power to build public improvements, has the power to levy, for all intents and purposes, it's an extension of the county performing an essential county function, which is promoting public health, safety, and welfare.
Leaders of the drainage district, are they county employees?
I don't believe so. I believe they're local landowners who were elected to serve in this role.
By whom?
They were elected by the landowners in the district.
It wasn't like a countywide election, right? And isn't there a special constitutional provision that establishes the drainage districts separately from the counties?
You're talking about Article 1, Section 18, that says that special assessments only for property benefited thereby, yes. It does authorize that.
And in our let's see, it seems like we have a relatively recent case, was it Fisher, where we said that drainage districts aren't?
That's the Fisher-Dallas case.
And they're not even suable, right?
Of the Iowa Municipal Tort Claims Act. That was the finding, yes. It's
sort of rewrite Fisher a little bit.
I mean, it was limited to whether it was a municipality. It didn't get into whether it was a county. And I think probably the most compelling argument in saying it's part of the county is several drainage districts are under the management of the Board of Supervisors in a county, directly managed by the county.
Symbiotic relationship, though? I mean, would it be possible for a county to provide services to a drainage district, such as the auditor sends out, helps them out on different things, but yet they be separate? Wouldn't that be possible?
Possible.
Question, how'd this get started? Did you guys demand it, ask for it? Is it a wish list, but you don't want to pay for it? What is it?
Ended it. In the record, I think at docket 40, we've got the district the district engineer, Scott Schramm's affidavit, he says they studied it. And the DOT paid for that study for the drainage district to look at possible options. But they concluded from that study that it was just not feasible. It wasn't practical, cost-wise, because they could invest in resiliency measures.
What I read from in your letter to, was that what you're referring to, other measures instead of this expensive project?
In the letter at that time when we were at the objection stage in front of the local board, but then when we filed our brief for the motion for summary judgment, we attached the drainage district, the district engineers, the DOT district engineer's affidavit. And he
Rosengren's affidavit at D0047.
Well, Mr. Rosengren's affidavit contains an email from a preliminary bridge consultant expressing an opinion. There's no, the authority to commit to projects at the DOT is with the district engineer and the highway commission. It's not with preliminary bridge consultants who are expressing opinions in emails. That's not how we commit ourselves to a project. That's the only attachment that I saw in Mr. Rosengren's affidavit.
Maybe a project development process question for me. If the DOT wanted to do this, they could do this and pay for it themselves, correct? And ordinarily, they don't assess costs, or maybe they do, and this is what I need the answer to drainage districts.
That is correct. If there was a valid transportation reason for doing the project, they could do it. If it was merely to help subsidize property ownership for local farm communities, then no, they couldn't do it. It'd be outside their jurisdiction.
It seems like because this is a reclassification case, this is a drainage district initiated project, and that they want to do it, or maybe not, if they're still in their discretion, but if they do it, to have the DOT pay 80%. If you guys wanted to do it, you would just do it. Okay.
Here's the thing that's so shocking about this. The DOT has hard, real costs for flood response, and that's $300,000 per flood event. There were 3 floods in 2019, and that data is from those floods. And so based on that data, they've estimated $8,500 per year on average that they're going to benefit from this levee improvement project.
That can't make sense, because doesn't the DOT care about the people that travel on its highways? Or is it just worried about its own budget and how much it's going to have to pay to do the rerouting? I mean,
in all fairness, it does care about the motorists, but it has a vast network of highways, and it can reroute people, although it's not a great thing if you're on that. However, at $8,500 per year, if they're going to be shouldered with a $10 million investment, it's going to take them 1,160 years to recoup that investment. That's not a responsible use of taxpayer funds.
looks at those things. I mean, they don't look at the ROI on that. I mean, by your logic, if this highway was so tremendously valuable, there would be no way to reroute people. There'd be even less benefit because there'd be no rerouting costs.
To recall that these interstates and this levee have been around for decades. And while there have been floods, traffic has been rerouted, and life goes on. The DOT does not need to spend, in its discretion, $10 million to raise a levee 1 foot.
All the highways, not just maximize the utility of this one highway for 3 flood events. You got to use the resources for the whole highway system.
Drainage district can force the DOT to make these types of investment at $10 million a pop. With 3,700 drainage districts throughout the state, you can consume the DOT's primary road fund quite easily. That's what scares the DOT. That's why we're here asking for the interpretations that we've asked for. And that's why we need you to interpret or to clarify, further clarify the scope of what benefits mean under 468, because you did that in the Drainage District 67 case. But all the discussion there was talking about benefits to parcels and benefits to owners. There was no discussion that we could see, or in any other case, where there was this concept of benefits to third-party non-owners who use a property.
is with the railroad, a railroad is in the business of making money. So the benefits to the railroad are derived from the benefits to the users. With a public project, you're paid for by the taxpayers of Iowa. So your benefits are the benefits to the taxpayers of Iowa, even though they don't actually pay to go on the road. Now, that doesn't necessarily mean that DOT should pay 75% of the project, but it does mean maybe that there's a reason to look at the classification issue as regards highways different from the way you look at it regarding railroads and landowners, isn't there?
And I would say what distinguishes this case from the railroad case is that we have 30745 addressing how, highway property should be assessed. And you don't have that, the railroads don't have that type of statute. And I think the legislature potentially foresaw this type of problem and created that statute for this express purpose.
If I am not persuaded, or if the court is not persuaded by majority that the drainage ditches count as a city or county and that 307.45 doesn't apply, where are we?
We'll get there through an equity analysis. Traditional equity analysis has been expressed in other cases. Clearly, this doesn't seem equitable when the real flood response costs are $8,500 per year, and they're seeking to force a $10 million investment from the DOT.
Why, are you talking about something other than the benefits analysis under the Drainage District chapter when you talk about equity?
Well, in Chapter 468, the assessments at the end of the day have to be equitable. And
So it's trying to decide if you're talking about something completely different, or you're still within the benefits process. Because before 30745 was enacted, would Chapter 468 have determined the classification?
well, I think that equity would still be factored in. Hopefully, it still would have been factored in. And, no one's ever raised this question about extending the concept of benefits to third-party users. And I understand that, the stakeholders involved, but I think the state is going to open itself up to these very skewed assessments if it accepts that type of novel formulation that's been presented here by the drainage districts.
Investment. When DOT decides, are they going to build a new road or widen a road, they certainly look at usage, how many people use it, how many users would benefit it, and that's how they do the ROI analysis, isn't it? Their own internal analysis?
Transportation projects. Those aren't, flood control projects where there are other alternatives that are less expensive and very practical.
Let me ask you, sort of going off the chief's point, let's assume that we decide that the entire case is governed by 468, all right? Tell me, what is the ultimate outcome? What instructions do we give on remand? I mean, when you answered the chief, it was sort of, well, we have to look at equitable principles. Tell me exactly what you would ask for in that situation.
I would ask that you further develop the concept of what benefits mean under 468 that you address so well in the Drainage District 67 Union Pacific case, to say that direct benefits to the parcel and its owner are fair game. And we can give a liberal interpretation of what benefits means in that context. But when you go outside that and you start looking to how third parties who don't own the property benefit from hypothetically benefit from a project, and then assign those benefits to third parties, to the owner of the property or the parcel, we think that that's an overreach. And it's not fair to public owners, for sure.
The presumption that reclassification reports are correct.
There is that presumption. It's a rebuttable presumption. And here, where there are admissions in the record by the drainage districts that they didn't assess in the same manner, that they used in the case of DOT property, indirect benefits ascribed to users and then assign those to the property owner, we feel that that is unfair. And
so if we were to go under Chapter 468 on remand, does IDOT have an obligation to come up with their own classification?
Question. I don't think they do, because if you read that Fulton and Sherman case, I think what the court was saying, they said it expressly. We need, in that case, there was a comparison of the complaining property owner to a single other parcel. And they said we need a comparison at least to a substantial portion of the drainage district so we can decide whether or not it's equitable or not. And in this case, if you look at the photographs that are in the record, you can see that the vast majority of these drainage districts are farmland. And so their admission that they assess farmland with lost crop values and then assess the DOT not in the same manner or differently, we think that that's enough of a comparison. A person complaining about a reclassification shouldn't have to go out and invest in a reclassification, survey the entire district, hire surveyors, hire engineers, get someone to map it out, then do all the calculations. That seems like a very high bar to give someone who wants to.
Or to be having your roads being treated like a cornfield? Does that seem right?
Not like a cornfield, we're asking that when they are assessed, that all the land is assessed by objective measures. You know, the district court commented that in this case, the crop loss were objective and finite considerations, and that the DOT's third-party user costs were subjective and infinite, potentially. And so if we could focus on things like land area and elevation, I mean, after all, water flows downhill, the higher the land is, the less it benefits, and the larger a property is, the more it benefits. And those types of things, I think, is what the legislature was getting at in 307.45 when enacted. And anyway, so we ask you to affirm the district court, and if you could clarify the scope not to extend indirectly to third-party users, that would be wonderful, and thank you.
Back to Mr. Goodwin.
This is a rather unique case and situation. The construction of an improvement is discretionary. The trustees can say, we're not going to do it. And the big issue that the trustees and the engineers concerned about is the district court ruling that Section 307.45 is applicable. We're saying that is not applicable to this situation. The drainage district is not a political subdivision. And there's cases, again, the Worth County, Mitchell County, and Des Moines Waterworks case said drainage districts are sui generis, one of a kind, unique. They're not in a classification. And so they are not in the classification of a political subdivision. That is the issue.
I pose this to opposing counsel. Let's say 307.45 is not the appropriate vehicle. If it's 468, what's your pitch? Where should we be if we're only going to go to 468?
Where we are now is plain and simple. We should be remanded to district court, and the district court can look at the reclassification report of the reclassification commissioners, and under Fulton versus Sherman, that case holds that the objecting party should make their own reclassification report to enable the district court to see which one's correct, because there is
Distinguish that from the situation where it was just two similar plats. Do the facts of that case distinguish it from this case where it might have been appropriate there to have required the objector to do their own classification, but where it was just two competing properties? Does that apply carte blanche to any objector?
That case also says to give enough information to make an analysis whether it's correct. From what I'm aware, it should be a full reclassification report by the DOT to compare to the reclassification report of the commissioners. That way the district and court can say which one is correct. But the realities are that still this is an improvement project, and the trustees can look at it and say, okay, here's what the analysis is, we're not going to proceed. If we don't, in our judgment, feel it's appropriate to, I think they're more interested in appropriate to the agricultural land. So
Don't proceed with this project. Current allocation is affirmed, then the next project that comes up, will the state be paying 75% for all future projects? You know, even things we can't contemplate today, we don't know about them.
well, there is, obviously there is an existing classification that they reclassified. So we have this reclassification. And that's what the DOT is objecting to. And as I say, on one hand, section 307.45, the district court says is applicable. We're saying that's incorrect. But again, the solution that you're asking about and I'm concerned about, okay, how do you make a reclassification that the DOT doesn't object to? Because they haven't said, no, we don't want to do the project. They've said, we'll pay $360,000 out of a 12.9 million. And the commissioner is saying, we're not going to do that. So that's where I think I submit it, remand it back to district court and have the DOT do their own reclassification report to show if and why the reclassification report of the commissioners is not correct, because there's a strong presumption that it is correct.
That it seems like the DOT is saying it's a good idea, but we don't want to pay for it. It's too rich for our blood. Would you agree with me on that? That the DOT actually doesn't think your plan's a bad plan. They just don't want to pay for it at the level you're requesting. Okay, thank you.
They want to pay $360,000 on a $12.9 project, and they want the farmers to pay the rest. And the commission, the trustees who are farmers are saying, that's not right. So that's what I hope to be remanded, and DOT can present their own reclassification report and compare it with the reclassification report that we have, and go from there. And again, the trustees can say, we're not going. It's a discretionary thing to make an improvement, but they're trying to cooperate and be helpful.
Thank you, Mr. Goodwin. The case of the Department of Transportation versus Honey Creek Drainage and others is hereby submitted, and court is adjourned for the afternoon.